Welcome to another edition of Florida Appeals Journal. I'm Jennifer Carroll, and today we're going to discuss a very hot topic facing attorneys and lay people in the law, and that's AI. So today's topic, AI and the law. Researcher beware. All right. AI, everybody's investing in it. It's a revolution. We all know that. So, what's going on for the lawyer or the layperson who wants to research and they're going to argue their case, whether it's before the trial court or the appellate courts? You need to be aware of a case. And I ran across it today because I have some clients who been representing themselves in other cases, and they're doing AI research and giving that to the courts. And I'm thinking, because I really, I still believe in doing independent research, right? AI has its place, but it's not yet perfected. So listen to what happened in these cases I'm going to talk about today. And that's going to help you navigate AI and how it's going to help you or hinder you. But used right, it should help you when you're practicing law, whether as an attorney or a lay person advancing your case to the different courts. This case is MATA. It's a New York case, MATAV Avianca. It's 678 F sub 3rd 43. That's Southern District of New York, 2023. And that's in the federal court. All right. So that's, they call that the first ChatGPT case. And what happened in that case? That's really a big moment, what they call an early watershed moment, that amplifies this issue about ethical implications in the use of AI in the legal field. In that case, you had one of the attorneys who was representing MATA, and it was an injury lawsuit that they had filed against an airline company, and that's Avianca. All right. Well, one of the attorneys representing the plaintiff in that suit turned to ChatGPT, relied on ChatGPT to help prepare a brief for use in that lawsuit and for use in court. The attorney apparently authored a brief that cited more than half a dozen supporting cases that contained decisions and outcomes that were almost too good to be true. All right. Now, the problem was opposing counsel tried to find those cases and they can't find them. So each one of those perfectly supportive cases were entirely fictitious, 100% made up. I was surprised when I saw that case. I'm saying, is ChatGPT doing that? At the time, now this is a 23 case, so and there's a 25 case I think that came after, but that's unbelievable. Apparently, this AI churned out party names, fact patterns, relevant issues, supposedly judicial analyses, and court holdings that were entirely, quote, hallucinated. And that's the term of art that's being used in the courts. Hallucinated. Unbelievable. So when you had opposing counsel for Avianca, the defendant, when they inquired about the cases, they couldn't find them in their research. It was discovered that the plaintiff's attorney had relied upon ChatGPT's legal knowledge or lack thereof before submitting it to the court, never took the time to verify. And see, that's the thing. You always verify, even when you're just researching on, Lexis, Westlaw. These are paid research software that attorneys use. You still got to check all the cases out there and see if something's been overruled. So you're always verifying. But here, an attorney relied on that, and it doesn't even exist. It was all made up. And the court was very upset and imposed fines and sanctions. And remember, you're in federal court, so you're going to get hit with Rule 11 sanctions in the case. And the courts, I think the attorney argued that he believed that ChatGPT worked like a search engine and was unaware of the possibility that the content could be false. Well, the court, wasn't going to be very sympathetic to that. So in this case, Matt, and looking directly at this opinion, the individual attorneys were sanctioned per Federal Rule of Civil Procedure 11B2. Attorneys who practice in the federal courts know this all too well, where they submitted non-existent judicial opinions with fake quotes and citations created by an artificial intelligence tool. But then they continued to stand by the fake opinions after judicial orders called their existence into question. So the opinion says that one attorney acted with subjective bad faith, violating Rule 11, where he had not read a single case cited in an affirmation of opposition and took no other steps on his own to check whether any aspect of the assertions of law were warranted by existing law. And then the court held another attorney acted in bad faith, where he consciously avoided confirming that cited opinions did not exist. So the court did not like it. This is the case that subsequent decisions cite to with respect to this concern about relying on AI for your legal research. Now, the court did say, quote, technological advances are commonplace, and there's nothing inherently improper about using a reliable artificial intelligence tool for assistance. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. So the attorney, of course, is going to be held to a high standard. Well, whether we call that high or not, it's an appropriate standard that you got to make sure you're supplying the court with legitimate, valid case law. AI is very tempting. There is an incredible allure to it, and justifiably so. You have efficient data processing, quickly drafted work product. But Matka just highlighted a potential problem, well, an existing problem, and a problem that does need fixing with respect to the quality and reliability of advice produced by easily accessible AI programs like GPT. You've got an expensive software, Lexis and Westlaw, that attorneys have to pay for. Private folks can, I would imagine, can pay for that as well. But when people were combing the internet and just looking for ChatGPT, and I'm sure there's other software as well, you still have to be very careful. You've got a certain level of proficiency, but you're still going to have a lot of issues and problems. And this Matka case just highlighted a very real problem that all practitioners really need to be aware of. There is another case, as just a Utah, looks like it's a state appellate decision, Garner v. Cadence, and that's 571 P. 3rd, 812. That's a May 2025. So in that case, the state appellate court held that the petitioner's counsel violated Rule 40 of the Utah Rules of Appellate Procedure by submitting a petition that contained fake precedent generated by ChatGPT. The court ruled that a fake opinion is not, quote, existing law that can support a party's legal contention. Okay, I think we can all agree with that. And they said sanctions are going to be warranted there. And in that case, the petitioner's counsel said, hey, my unlicensed law clerk did this research. And the appellate court said, well, you're the attorney, you're responsible for it. So you're the gatekeeper. So you're going to be held liable for that, for whatever your law clerk did. Licensed, not licensed, doesn't matter. I want to do a quote. I thought this was pretty interesting what the court said. As is most likely common in this profession, legal research has improved over time, going from the use of digest books to online databases from Lexis and Westlaw. And I remember the days when we had the Federal Digest, you had the blue books with all the condensed head notes. And when you advance over to computerized research, there's still analysis and a lot of thought that goes into what terms that you're going to put in that's going to help you get the right result. And we say the right result, the accurate result, answer to the questions that you're posing in your search. And now, quoting from the case, litigators are beginning to make the jump from those databases into the world of AI. When done right, AI can be incredibly beneficial for attorneys and the public. However, the current state, this is a May 2025 case. However, the current state of AI has its shortcomings. The legal profession must be cautious of AI due to its tendency to hallucinate information. Um, while technology continues to evolve, attorneys must verify each source cited in their legal filings and must still read the case to ensure the excerpt is existing law to support their propositions and arguments. You see, most attorneys don't like to do that. You can think it's tedious work, but it's part of really being a lawyer. And even if you're not a lawyer, you're advancing an argument. So it's all part of advancing a valid and persuasive argument. And to attorneys, and as attorneys transition to the world of AI, the duty to check their sources and make a reasonable inquiry into existing law remains unchanged. So, continuing, we emphasize that every attorney has an ongoing duty to review and ensure the accuracy of their court filings. And in the present case, the petitioner's counsel fell short of their gatekeeping responsibility when they submitted a petition that contained fake precedent generated by ChatGPT. So, certainly, without question, AI has a lot, without question, to offer, but it's got to be used properly and responsibly. Sure, everyone agrees to that. We'll put those citations on the Florida Appeals Journal citation so that you can look that up. I encourage you, if you're using AI, you want to read those cases and be fully aware of your responsibilities to the court and to the legal field. As usual, any questions, let us know. Thanks for attending today's edition of Florida Appeals Journal. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.